you very, very much for the invitation. It's a privilege to be able to do this. And I myself personally, and from Rod Cullerton, thank you for being interested enough to come along and find out the direction that politicians that we have elected to represent us are the very people who have cancelled every title deed in Australia. And at the end of the information, I have them all on a slide, each one who physically terminated your title deeds. And they did this not only outside of the parliamentary structure, they also did it outside of the Constitution, because there is no power in the Australian Constitution for a corporation to hold the information of your property. Now, I'm going to talk a little bit more tonight about, that's the Australian Constitution. It is 1,006 pages. It took me 3 weeks not to read it, just to go through it and make up an index of every note that is in this document. The Constitution started being developed in 1883. And they worked on the actual production of the Constitution right up to and including 1900. So 17 years. And when you think about it, that the colonies were all separate. So there was Moreton Bay, Botany Bay, Melbourne, I'm not sure, here in South Australia and Western Australia. And sometimes there would be almost a year between the meetings that they had. So what is in this document, and when I finish talking on the Constitution, I'll pass it round and have a look in it. It's a little bit moth-eaten and it's got lots of tags in it because this was with me in Canberra. This was what I went to if I wanted some information on the Constitution. It was ironic, it was 1999, and I was the first senator that actually took, not this laptop, but a laptop into the Senate chamber and actually took emails live to actually ask questions of the ministers. They didn't like it. Anyhow, so I had the laptop and my Constitution, but if I walked in with my Bible, they knew they had upset me. But the interesting thing was, I used to get heckled like you would not believe. But the moment I stood to read something out of the Bible, when they were passing a bill that was contrary to God's law, it was just dead silence. So that's the power. Anyhow, okay, so what I want to talk to you tonight about is actually this section of the Constitution. And later on, up on the table up there, there's 3 copies of the petition that Rod and I are going to take to the House of Commons in England. And the reason we're doing that, I'll explain. It goes right back to the Magna Carta in 1215. England actually had a civil war from 1205 to 1215. The previous king, King Richard, was in the Holy Land chasing the Muslims out of Jerusalem. Back in that era, the barons who held large parcels of land in England all had standing armies, their own personal armies. King Richard asked them if they would contribute some of their army to augment his to go to the Holy Land. So they did. And as a reward for that, King Richard actually granted the barons parcels of land in proportion to however many men they contributed. So they were successful. Unfortunately, King Richard, on his way back from the Holy Land, was captured. And for 10 years, the English people had to pay ransom to his captors over 10 years. So by the time he got out of that and was heading back to England, he didn't have much beer money. So he was raiding castles to get some wealth back, and got shot through the eye with an arrow. So that meant then that his younger brother, John, and we all know about King John and Robin Hood, that's the era. That really did occur. So King John actually started revoking the land grants that Richard had given to the barons. Now the barons generally were busy fighting one another to protect their little patch, and so they decided to get their act together, and in 1205 started a war against King John, which culminated in early 1215 with them actually capturing the Tower of London. Any of you been to England and been to the Tower of London? Yeah, there's a few nods. Yes, okay. See, there was no Buckingham Palace or Windsor Castle, right? The sovereign of the day actually lived in the Tower of London. There's multiple towers, actually, that make up the Tower of London. So, obviously, the Magna Carta was prepared. You don't write a document like that before morning tea. So, the option was given to John, either sign the actual Magna Carta, which means Great Charter. Right? His options were to sign it, or they were going to take his head off. Now he did on two latter times actually revoked signing it, but it still stands today. So prior to John signing the Magna Carta, the sovereign had absolute sovereignty. I'm going to put that down for a minute. The sovereign had what is called absolute sovereignty. Whatever the sovereign said, went. what the Magna Carta did, it took that entire sovereignty off the sovereign, left the sovereign with only one power, and that was the ability to withhold a bill coming through the Parliament if the sovereign thought that wasn't in the best interests of the English people. That, well, used to stand until 1986, when they brought in the Australia Act. So, the sovereignty that was the power of the sovereign up until then was transferred to the House of Commons. So anyone got any idea why it went there? Why not the House of Lords?
They're the robber barons.
No, the barons are actually in the House of Lords. No, it's the people's house.
Yeah, the people.
Yes.
For the people, yeah.
So that put the power, the absolute power, back in the hands of the people. And when, like we did in 2011 and 12, or prior to that, right around Australia, we all elected every premier that there is in every state. So we had King John taking the land off the people, and that's exactly what was behind the Magna Carta. And actually there is a section in the Magna Carta that actually gave 25 barons the right of veto over any decision that John or any subsequent sovereign has made. Not really known, but it is there. And when you put 25 of the land barons, and you put 25 of the bishops of all the cathedrals in England, there's 50 of them actually, then you actually have the Privy Council. And that's why, later on I'll explain, we have a plan A, and B, and C. So coming back to this section of the Constitution, it's actually the empowering act that was passed in the House of Commons in 1900, on the 9th of July 1900, that actually brought our Constitution into existence. Now, go back to before then, in the mid-1800s, and I'll use Queensland as an example. Queen Victoria actually proclaimed Queensland into existence. But 1856 is a long way after 1215. So how was Queen Victoria able to divide the state of New South Wales into two? Very simple. Each of the colonies, all 5 of them, all had a single legislative council. So New South Wales passed a bill, and at that stage, and that goes right up until 1931, any bills that were passed by any of the colonies all had to be taken to London, brought into the House of Commons, and then passed into an act. But it also had to have, with the consent of the Lords Spiritual and the Lords Temporal. So when Queen Victoria proclaimed Queensland into existence, the wording was I, Victoria, with a bill from the colony, debated and amended in the House of Commons with the consent of the Lords Spiritual and the Lords Temporal, I proclaim. So that's the power process. And this is exactly why the petition that we're taking to the House of Commons, asking for the Governor-General's position, like even the House of Commons can't sack the Governor because the Governor is appointed by the Sovereign, or should be. It isn't now. It's actually appointed by the Premier of the state. And I'll tell you something ludicrous in a few minutes. That was how the actual Constitution came into existence. So Rod and I are following a very similar process. We're setting out to get 100,000 signatures on that petition. Yeah, it's going to take us a while. There's only 2 of us. Well, no, there's not only 2 of us now. There's lots of people out there with copies of the petition. Right. The reason we are aiming at getting 100,000 is the English Petition Act actually states that if a petition is presented to the House of Commons with 40,000 signatures, it has to be acknowledged. Doesn't have to go anywhere else, but it must be acknowledged by the House of Commons. If a signature with 100 or in excess of 100,000 signatures is presented in the House of Commons, it has to be debated on the floor. Right? So we're immediately inside the process where we want to be. Rod in 2019 came up before the grand jury, and the grand jury is 25 of the Lords Spiritual, 25 of the Lords Temporal. And he asked a series of questions relating to what Whitlam did in actually removing the word Commonwealth from all legislation. Where did he get the power from that? The interesting thing is, in this document, there's a section called Section 51. And within Section 51 is very, very well articulated the powers that the House of Representatives and the Senate have. Where I've got that yellow highlight, now that is page 346 when you're looking for it later on. And just to get it absolutely correct, right? The way the Constitution works, so that's the actual clause of the Constitution, and it's Section 5, which happens to be in the English section of the Act. Section 128, currently the last section of the Constitution, is the referendum Constitution. All right? So in each one it says this Act, and believe it or not, I can even read it, there's a little 22 there. So if you want to know what the note 22 tells you, right, it tells you about the Act. Then and all laws, which is 23. So that's where we were just before. Come on, flip over. So, and all laws has the note 33, Right, and I'll read the start of it because this is really important. No difficulty is suggested by the words "and all laws" made by the Parliament of the Commonwealth under the Constitution. The words "under the Constitution" are words of limitation and qualification. I'll just read it again. No difficulty is suggested by the words "and all laws" made by the Parliament of the Commonwealth under the Constitution. The words "under the Constitution" are words of limitation and qualification. So the Parliament can't say, oh, I think the section 5 of the Constitution just gives us the power to do anything. No, it does not. The Parliament is restricted to be able to only pass laws that are expressly set out. And in the same section, or same note that I'm reading, a law in excess of authority conferred by the Constitution is no law. It's wholly void and inoperable. It confers no rights. It imposes no duties. It affords no protection. So I can think of a few laws that the Parliament have passed, like Mr. Whitlam taking the word Constitution. Where does he get out of Section 5 of the English Act the power to take the word out of every piece of legislation that's ever been passed? Particularly when you read that first part that I read to you before, the words "under the Constitution" are words of limitation and qualification. And they can't take a word out of one section. It goes on, to be valid and binding, they must be within the domain of jurisdiction mapped out and delimited in expressed terms. So it's what's called black and white law. The Parliament can't say, oh, well, I think that says this. Sorry. Immediately, that law is void. So, and that's another part of what we're doing with the petition. We're not going to the House of Commons asking to change the Constitution. We're 8262. We're not asking the Parliament to change any of this.
No.
We're asking them to rectify the abuse that has been made to Section 2, and Section 2 says very, very clearly, the provision of this Act referring to the Queen shall extend to Her Majesty's heirs and successors in the sovereignty of the United Kingdom. Where did they get the Queen of Australia? Out of Section 2.
Made up.
Right? They can't. And then down in 5, this Act and all acts made by the Parliament of the Commonwealth under the Constitution. So Whitlam takes Commonwealth out of the Act, right? Shall be binding on the courts, judges and people of every state and every part of the Commonwealth. So that's the reason why we're going to England, to the House of Commons, not to ask them to fix anything in here, but mind you, it needs some fixing. We're asking them to rectify what has been done to their Act. Because up the top here, the Constitution of Australia, Constitutional Act, 63 and 64 Vic, which is referring to Queen Victoria. Okay, so that first 9 sections in this Constitution is actually the Empowering Act. It's part of our Constitution. So, deeds don't exist anymore. That took me over 18 months to understand what had occurred. I got a rather irate email from one of the directors of a private company called PEXA. And PEXA carries out 80% of all land transaction in Australia. And he told me in no uncertain manner that they do not hold title deeds. And the reason they don't is there aren't any. The individual states, as it's rolled around Australia, have all cancelled all of the existing title deeds and now refuse to actually provide them. So what is on these two companies' computers is your lot number and your name. And that's it. It's just a piece of binary code. The Commonwealth Bank, Morgan and Stanley, and a company called Link. I think a lot of people would have heard of BlackRock.
Yes.
Right. Well, Link is the sleeper, the real sleeper. It is as big as BlackRock. BlackRock holds major shares in Link, and Link holds major shareholdings in BlackRock. Just a neat arrangement.
That's not chain link. That's different, is it?
Yeah. That's just two private corporations holding shares in each other. So the Commonwealth of Australia Constitution Act 1900 UK, you'll notice that I always go back to the English Act because that's where the power came from to create the Constitution. And state and territories, or binds, each state and territory to function within the granted powers expressed within the Commonwealth of Australia Constitution Act, England, 1900. Now, COAG is an entity, it's C-O-A-G, right? So it's a coalition of Australian governments, right? I'm not quite sure when its conception was, but there is no constitutional standing for COAG, and there is no state legislation to underpin COAG. It's just a meeting of the premiers who decide collectively what they are going to do outside of the Parliament. COAG, what they did, they created an entity called ARNECC, A-R-N-E-C-C. So that's the coalition of registrars around Australia. Once they had established this entity, then the entity itself then created a document and a process of electronic lodgement networks. So we went from having your local real estate person being able to prepare documents and then taking them to the local titles office, where it was processed onto initially both the purchaser's copy, whether it was the parchment one or whether it was a paper certificate. It was actually updated into the new purchaser's name. So then the second copy was held by the titles office. That was updated at the same time. The third copy, under the Torrens title, was then placed in the archives here in Adelaide. So Torrens was a member of the South Australian government, and it's actually a lot earlier than I thought before. I did a bit of checking up. 1856, he brought in the Torrens title because the boys in the titles office were being a little bit naughty and making a title deed for the genuine purchaser, and then making an identical one and selling it somewhere else in Australia. So that's what was the actual reason for the Torrens title coming in with 3 identical original documents. And this is what we're going to be arguing on Tuesday when we go into the archive itself. Now, we don't know how we're going to go, but we are going to be all quiet, just discuss with them, because all 3 of those titles that were created when the first parcel of Crown land was transferred to a person, they are property, the physical document, all 3 of them. And the argument there is, well, if somebody hadn't bought that, you would have no title whatsoever, right? They are all original, not copies. They are original documents, and you are entitled to see that copy of your title. So, yeah, because of the electronic lodgement network was, as I said, Stanley and Morgan, Commonwealth Bank and Link put up $600 million to develop the code under which that process operated. Yeah, so the ELNOs are the 2 private companies that this entity that has no standing created, that actually holds that little bit of binary code, and that's the only link between your lot number and you owning your home. So individual states and territories in 2013 proceeded to adopt the Electronic Conveyancing National Law. It's not an act of parliament, it is just a law. To their respective parliaments, and the states and territories knowingly, in doing so, that the individual states cannot alter their now state act without the consent of all other states. So you have a New South Wales Act, that's how it started. Barry O'Farrell, as the Liberal Premier of New South Wales, copied a Canadian Act, passed it through both houses in New South Wales, took it to COAG, and then it took a year for all of the premiers to agree that they would adopt the New South Wales Act. But none of them can change it without the consent of every other premier. That's the sheets that you, I hopefully that you will take home, take at least one home with you. For a person to sign the petition, they must be able to read what is called the prayer. And that's where we ask for the Governor-General, the governors, anyone who is appointed to public office, then anybody who has been elected to either the House of Reps and the Senate, who have sworn allegiance to the false Queen of Australia, are ineligible to stand. So it's going to take 12 months for this process to roll right around Australia. No, you won't be without a government, because immediately on the Governor-General being replaced through the Constitution, right, whoever is the opposition of the day will be appointed to actually carry out a federal election. Now that's exactly identical to what happened when the Governor-General Kerr sacked Gough Whitlam. He didn't make Fraser the government, right? He only appointed Fraser for the purpose of conducting a federal election, and the questions that were tied up in the Parliament that caused the double dissolution, that's getting a little bit too difficult to explain it totally, but everybody knew that Whitlam was trying to attach social issues onto a bill that was distributing Commonwealth funds. And Section 51 says a bill must only be for one singular purpose, because the Senate was hostile to him and wouldn't pass his social agenda. So Kerr correctly then dismissed Whitlam and only made Fraser a caretaker government for the purpose of holding a federal election. So that will step down in every state level, be federal first, and then each state will rotate around. So it won't be a point of, oh, there's no government, right? And while I'm on that, the Governor-General issues a writ for a federal election. The Governor of the state issues a writ, say for South Australia. On that it will have, when the rolls close, the day of the actual polling, right? And then the actual writ also contains eventually the names of all of the people who've been elected in South Australia at that election. It also contains a phrase that the writ is active from the day the Parliament meets for the first time after being elected and ceases 3 years later, which then results in another writ for the next election. A government has no power and no jurisdiction to pass any act or carry out any action outside of the period on that writ. The other issue is that one parliament cannot bind a subsequent parliament because they only have the power and jurisdiction within the period described in the writ for their election. Okay, there's the gentleman who morphed COAG into the National Cabinet, thinking that if he did that, he could actually bring the National Cabinet under the 30-year embargo. That lasted about 2 or 3 months before it came through a High Court case in which the High Court ruled that the National Cabinet has no powers, has no jurisdiction, and therefore is not eligible to embargo anything. So that's PEXA. Now it's a limited company. It's not on the stock exchange. So 8 times out of 10 of everyone in here, it'll be PEXA that has that very small piece of binary code that holds your lot number and your name. But it is not a legal title, and you cannot use it for any purposes of security. So just stay where you are. Then this is the second one. That's an abbreviation. It's actually simply Australia Proprietary Limited, and they hold the other 20% of binary code that has the lot number and the person's name. So now nobody knows where their mainframe computers are.
What happens if it crashes?
Well, one would certainly hope that the day before they had made a backup copy. Well, see, it's another reason why we're pushing the archive so much. But the problem is that South Australia actually swung over to electronic lodgement in 2017. Now, I don't know whether at the same time they cancelled all the titles then, but you certainly can't get a copy even of an old one from the new private company that now purports to record the transactions. So when COAG was actually shut down, there's all of the committees that this just wasn't the premiers going out somewhere and I'll say having a weekend off. There was a Federal Finance Relations Council, Disability Reform Council, Transport and Infrastructure Council, Energy Council, Skills Council, Council of Attorney Generals, right? Education Council, Health Council, Joint Council on Closing the Gap, whatever that means, Indigenous Affairs Council, Australia's Data and Digital Council, and Women's Safety Council. Now, they are all duplicates of what exists under the parliamentary process. But you imagine the amount of bureaucrats that are involved in that. Yes, and there is no power for them to have ever been created, and they have no jurisdiction. The three things, if you're ever looking at legislation, you read it within the back of your mind. Where is that Act's power? Where can that power be actually carried out? And the other one that is really important as well is the dictionary. Every Act should have a dictionary to explain the meaning that makes up the powers and the jurisdiction.
Yeah, the code.
Statute of Westminster, this is part of our argument, or our part of the reason for asking what we're asking. Before 1927, all of the parliaments, even now, they're now states, right? They can pass an act through and to the upper houses, except Queensland, because we don't have one. And then that was law. So from 1931, both the states and the federal government also had the power to enter into contracts overseas. Prior to that, the legislation for overseas and that used to have to be actually taken to, again, the House of Commons. So if ever Australia became a separate nation, it was then. But it was still under the Crown. Okay? And it says, whereas the delegates of His Majesty's government in the United Kingdom, the Dominion of Canada, Commonwealth of Australia, Dominion of New Zealand, the Union of South Africa, was still a member of the Commonwealth at the time, the Irish Free State and Newfoundland. At Imperial Conference held with Holden, this is sort of on the cusp of Old English, at Westminster in the year of our Lord 1926, did concur in making a declaration and resolution set forth in the report of the said conference. Well, that's all the powers that it actually granted to every Commonwealth government. This is, and whereas it is meet and proper to set out by way of preamble to this Act, that inasmuch as the Crown is a symbol of the free association of the members of the British Commonwealth of Nations, and as they are united by a common allegiance in the Crown, it would be in accordance with the established constitution position of all members of the Commonwealth in relation to one another, that any alteration in the law touching the succession to the throne, what did they do in the Australia Act? In the law touching the succession to the throne, or the royal styles and titles, shall hereafter require the assent as well of the parliaments of all the dominions as of the Parliament of the United Kingdom. So when the premiers of all the states wanted to bring in the Australia Act, while Whitlam actually changed the royal styles, titles and signet without no authority. This is all part of our petition that we are actually putting to the House of Commons. These are the reasons why we are absolutely sure that once 100,000 signatures land in the floor, because I'm taking the actual physical papers that you are signing. It'll be more than a couple of suitcases too.
Take the luggage.
Yes, because it has to be the original signature. Okay?
Whatever you've got now. land.
Yeah. So Whitlam altered the royal styles, titles and signet. He back in 73 actually took the word Commonwealth out, and that offends section 2 that I read out of there before, that the Constitution is intrinsically tied to the sovereign of
Yeah.
Great Britain, Northern Ireland and Scotland. It's a tri-crown. So here again, for anyone to change the royal styles and titles and signet, they have to get the consent. Well, obviously India no longer is, and South Africa no longer, although they still recognise the Commonwealth, both of them. So what the premiers did, they just wrote a letter to the House of Commons and asked them to pass the Australia Act. So there is a UK-Australia Act. It's only a little bit over 1 page. Her Majesty did give royal assent to it, and the but is that clause 15 of, again, that's the Empowering Act for the Australia Act. Her Majesty deemed that in its introduction, right, it had to comply with section 128 of the Australian Constitution, which they did not do. So everything that they have done from 86 onward, every law that has passed federally and in every state government is void. And the Privy Council has indicated to Rod that that is correct. There has been no legal legislation in Australia since 1986. Now, here we get to the good bit. And there they are. The traitors, New South Wales, Barry O'Farrell. He was the guy who took his act to COAG that eventually has taken all of your title deeds away until we get at him. ACT, Andrew there. So they have Parliament in ACT. They weren't supposed to under the Constitution. Tasmania, Laura Giddings. So we've got Barry O'Farrell, Liberal, Andrew Barr, Labor, Laura Giddings, Labor, Northern Territory, Terry Mills, Country Liberal, WA, Colin Barnett, Liberal, ACT, that's Julie Gillard, she was the Prime Minister of the day, Queensland, Anna Bligh, Labor, Victoria, Ted, who can read French? Liberal, and the not so honourable Jay Weatherall, South Australia. He himself personally took it on himself to cancel your title deeds. What are you going to do about it? Who's heard of the Fabian Society?
Yes.
Okay. How many of you have got an ASIO file?
Probably all of us.
I have, because I dared to actually contact the tables office in Canberra and requested a copy of Bob Hawke's 100th anniversary speech to the Australian Fabian Society. So all the time that Bob Hawke was Prime Minister of Australia, he was a member of the Fabian Society. And in the speech, he makes this quote. Now, I don't think he was bright enough to have thought of it, but what he has...
No child in poverty.
I should have prefaced that by, it has been said. The inevitability of gradualism. Lock it in your mind, right? The inevitability of gradualism. And the example that I give of that is how many of us have been wading down the beach, knee high in the water, enjoying ourselves, and the waves come in and the waves go out. And they come in and they go out. Can you tell whether the tide's coming in or going out? You can't. It is so gradual. So what Bob Hawke was saying, he will change all of us so gradually that we will never know we've been changed. And isn't that where we are today? Their logo is a wolf in sheep's clothing. Yes. So where they have the lion and the unicorn, right? In actuality, the South Australian government has been trading in currency, and they've done that through the equities exchange in America. Now you hear a lot of people saying, "Oh, all of America owns all of Australia because all of the governments are registered in the equity exchange." In actuality, they are, and I can give you an example, the Queensland government in this fiscal year sent a directive to the equities exchange that they are going to issue $14 billion of bonds on the open market. So at the moment a government starts actually physically trading in money, right, they lose their statutory standing. They are a corporation. Got nothing to do with them being registered over there. The purpose of a government is to receive our taxes and justifiably and fairly distribute that for us. No government, no state government has jurisdiction or power to go overseas and borrow money. Who's going to pay the $14 billion that Queensland is borrowing this year? My grandchildren. Yeah. So the fact that they are stamping on those documents, the lion and the unicorn, yes, it is. It's treasonable. Yeah. And the same thing applies in all of the court documents. The seal that goes on magistrates, district court, Supreme Court, they are all exactly the same seal. I have a very close friend back on Tamborine Mountain. Lorraine and I lived there from 1970 till 84. And this friend, her grandmother, they weren't German, they were actually, or they became Swedish, they were actually Jewish. So they had to get out of the Russian sector of Berlin. The one thing that she did do was actually bring the title deeds to their home, her grandparents' home. And that was handed down eventually to this lady. I don't want to use her name. So, just before 2007, this lady started negotiating with the unified German government. And in 2007, she was paid reprobation for the value, the market value of her parents' home. And that was multi double-figured millions. So that's how important that title deed is. Even if you've got a certificate, right, and it actually has in fee simple, right? Go back to Queensland. Queen Victoria, she's actually has proclaimed Queensland to exist. She then ordered Ferguson Bowen to establish the Legislative Council, the Upper Council, which we did have originally a Senate, what we refer to as the Senate, and also the Executive Council, through which, here in South Australia, your governor should actually select from the public, not the parliament, from the public, people with certain skills to report to him on how the government departments are functioning. That's what should make up the Executive Council. So you see, that gives you separation from the parliament process and the governor giving royal assent to a bill. That's how it should work. Now, I haven't checked in South Australia, but in Queensland, Micah Hearn altered the governor's role, made himself and his cabinet the members of the Executive Council. So it's the fox administering the fox house.
Yeah.
So if you want to do something, do a little bit of research, find out who the members are currently of the South Australian Executive Council. And it will worry the bejesus out of them that you're asking questions. Yes. So, get back on track. Yeah?
Can we do
Okay.
anything ourselves to put that back in on the documents?
The in.
Yes.
Yeah, there's nothing like people pressure. Western Australia passed an Act of Parliament to allow the Indigenous people under the Heritage Act to actually be able to go onto a property and, you know, you'd like to them, because they excluded every property that was less than 1,100 square metres. So, all the townies are out, you're right, you're free and clear. But the poor farmer out there can't even now dig a hole for a post in, let alone plough a paddock to plant a crop until he gets a permit. And the permit is $1,200. Now this one, I smelled a rat. The Western Australian government, on day one, introduced the bill into Parliament, debated it, sent it off to a committee, came back to the Legislative Council, they sent it up to the upper house, was debated, passed was presented to the governor and he gave assent. I no longer say royal assent. All in one day.
Or,
The bill is 2 paragraphs. And it is a revenue bill for the government. Does not even mention Aboriginal heritage. So, Rod and I sort of did a bit of and within a month they said, oh, we're going to defer it for 12 months. And then I'm not sure whether it was Darren or Derek, one of them sent a question to the Attorney General and they cancelled the bill. So yes, if you can get it taken out, you can get it, well they've taken the in out,
yeah.
we can get the in back
We
in.
need you to.
Okay, this is Bill number 9 of 23, assented to on the 26th of the 3rd, so that's January, February, March 2023. South Australia, First Nations Voice Act 2023. Your Parliament in South Australia has already implemented the voice.
What?
Now-
Oh, I know, they changed my names about it, so.
Yeah,
But I believe the Prime Minister in one of his statements stated that he already knows the outcome
oh, yeah,
of
cool.
these statements.
Look, I'll leave this copy here with you for your group, right? Because what it actually gives them the authority is to be consulted on every bill that is introduced into the Parliament. They now have to, once this committee is actually established, the Parliament has to advise them of every bill that they pass. They have a right to actually sit in on Cabinet on any bill that they determine infringes their Indigenous rights. That's only just one little part of it. Anyhow, I'll leave this with you. Annual engagement hearing with administration units, interaction with the South Government, South Australia Government, meeting with Cabinet, State First Nation Voice to meet with Cabinet, protection of communication, etc. with the Cabinet. They are going to be seeing Cabinet documents. Do you get to see Cabinet documents? No, you don't. Administration and resourcing, you can imagine what that's going to be.